Good afternoon and welcome. I'm Greg Duge with Foley and Lardner, and I'm pleased to welcome you to today's Employee Benefits broadcast. In today's broadcast, we will address the Patient Protection and Affordable Care Act beyond the newsletters. In choosing this topic, we are aware that you likely have received a multitude of newsletters that discuss PPACA in considerable detail. Yet our experience has been that employers continue to have questions about what is flat out required and where there may be options. We will attempt to explore that theme today. I'd like to take a moment to introduce our program speakers. First, we have Andrew Greger. Andrew is an associate in the firm's Employee Benefits and Executive Compensation practice. His practice focuses on employee benefits, ERISA, executive compensation, and related issues pertaining to implementing and maintaining retirement and welfare plans. And again, I'm Greg Duge. I'm chair of the firm's Employee Benefits and Executive Compensation practice. My practice involves the representation of employers with respect to ERISA and tax issues that arise in connection with the pension, profit sharing, and welfare benefit plans that they sponsor. Before we begin the substantive presentation, I'd like to go over a few housekeeping details. Today's program will last approximately 1 hour. If you experience problems with Adobe Connect, please call 888-569-3848 for technology assistance. For audio assistance, dial star, then 0 on your touchpad to reach an operator. To ensure that you get the most out of today's presentation, we encourage all participants to maximize the PowerPoint to full screen usage. You can do so by clicking the full screen button located above the slides. Today's PowerPoint presentation is available by simply clicking on the Download Files button to the right side of the presentation. And again, as a reminder, today's program is being recorded and will be available on Foley's website by early next week. Finally, Foley will apply for HRCI and CLE credit after the web conference. If you did not supply your CLE information upon registration, please send an email to Jackie Polson at jpolson@foley.com. As a final note, those seeking Kansas, New York, and New Jersey CLE credit are required to complete the attorney affirmation form. A 4-digit code will be announced during the presentation. Please email this code to Jackie Polson at jpolson@foley.com to receive a copy of the form. And with that, I will now turn things over to Andrew Greger for the first part of today's presentation.
Thanks, Greg. Thank you for the introduction. So as Greg mentioned, today we're going to go through and talk about some of the options available under the Affordable Care Act, options that might not be obvious at first blush. In order to do that, we're going to start by having a quick refresher on the Affordable Care Act, specifically the employer mandate, and that discussion will provide the background for the remainder of our discussion, which will involve discussing 7 selected points that might not have been covered in newsletters you've already read or seen, or the issues could have been covered, but maybe not in a way that made it clear what options are or decision points are available to employers. And we hope that with this discussion you can take away an understanding that the Affordable Care Act compliance is not a one-size-fits-all proposition. Employers have options when deciding how to handle the employer mandate, which is what we're going to focus on. And we hope that you'll better understand the options available in compliance with the employer mandate, and that you can, from there, you can make the choices that best fit the needs of your organization. So, as I imagine we are all well aware, the Affordable Care Act has been around since 2010, and it can be considered to have 3 parts. The marketplace, which is the health insurance exchanges that are run either by states, such as Covered California here in California, or the federal exchange, which runs exchanges for a number of states that chose not to run their own. On the exchange, individuals can purchase coverage. And in 2014, employers with no more than 100 employees can also purchase coverage on the exchange, as well as large employers beginning in 2017. Another element excuse me, of the exchange is that taxpayers with household income less than or equal to 400% of the federal poverty line might qualify for premium tax credits. And as a reference point, in 2014, the 400% of the federal poverty level for an individual is $46,680, and for a family of four, $95,400. Again, that's 400% of the federal poverty level, and that 400% number is going to come up a lot today as we talk through the different requirements and options. So the other two elements of the Affordable Care Act are legal rules. These are substantive legal rules that require things. Examples are the coverage of adult children, or the requirement to have no cost sharing for participants in preventive services. And then the third part where we'll focus today is tax rules. And the employer mandate is one such tax rule, including its subparts of providing affordability or a minimum value. And the individual mandate is another one of the tax rules. That's the requirement that individuals have coverage, minimum essential coverage, or pay a tax. Now, the employer mandate is a tax rule that is implemented through two penalty provisions. We're going to call them conveniently penalty number 1 and penalty number 2. Penalty number 1 is the requirement for large employers to offer minimum essential coverage to full-time employees and their dependents. Full-time employee is defined to mean an employee that averages at least 30 hours per week. And this is the code 4980HA penalty, which you may have heard of this as the subsection A penalty. As we'll discuss later, penalty number 1 does not require that the coverage offered be affordable or provide minimum value, just that it be minimum essential coverage, which is a much lower standard. Originally, the penalty number 1 and penalty number 2 were going to take effect for this year, 2014, but as you may know, back in July of 2013, the IRS came out with Notice 2013-45, which delayed, which provides some transitional rules, including delaying the penalty until 2015. So there's no penalty, no employer mandate penalty this year in 2014. And in 2015, the requirement to provide coverage to your full-time employees is met if you provide coverage to at least 70% of your full-time employees. Then, starting in 2016 and beyond, the employer mandate, this penalty number 1, will be met. You'll have met this requirement if you provide coverage to at least 95% of your full-time employees, and that's the standard regulatory rule that will apply going forward after beginning with 2016. So penalty number 1, which again is the requirement to offer coverage to full-time employees and their dependents, is a $2,000 per full-time employee penalty. That's the annual number. The penalty actually applies on a monthly basis and is $166.67 per month per full-time employee. And the offer of coverage, on the other hand, that's required through this penalty number 1, or you have to meet the requirements, is met by offering coverage once a year. So even though the penalty itself is actually broken down on a monthly period, you can meet the requirement by offering coverage for the plan year. And the penalty is triggered, it's important, when at least one full-time employee enrolls in coverage and receives a premium tax credit through the exchange. But as we said a couple slides ago, the premium tax credits are only available if the employee's household income is less than or equal to 400% of the poverty level. In calculating the penalty, the first 80 employees for 2015 and then going forward, it'll be the first 30 employees, don't count. So you don't pay that $2,000 penalty for those first 80 employees in 2015 or 30 employees going forward. But it applies with respect to all full-time employees, whether or not offered coverage. So this penalty number 1 is really the big one, and it's the one that you want to that failing to meet is going to have significant impact. And if you offer coverage, say, in 2016 when we have the regular rule of 95% of full-time employees, if you offer coverage to 94% of your employees, that's just as bad as offering coverage to 0. And as an example, if you say an employer has 6,000 employees, doesn't offer sufficient coverage to their full-time employees, that penalty for that employer, the penalty number 1 would be $11,940,000. So this certainly is a big number that wants to be, I think all employers are going to want to avoid. Penalty number 2, on the other hand, this is the 4980HB penalty, the subsection B penalty, and it requires the penalty will be imposed if the minimum essential coverage offered to full-time employees does not either provide minimum value or is not affordable. And if the coverage does not provide minimum value and or is not affordable, then the penalty will be triggered if an employee goes to the exchange, applies for coverage, receives coverage, and receives a premium tax credit. Then the employer will be subject to this penalty number 2 for that employee, that one employee. This penalty, like the penalty number 1, doesn't apply in 2014 through the transitional rules. And the definition here of minimum value and affordability, the key terms for this penalty number 2. Minimum value is an actuarial determination of whether the plan is expected to pay at least 60% of covered medical expenses, taking into account deductibles, copays, etc. The Department of Health and Human Services has released a useful spreadsheet that you can download and then key in your plan's information if you so desire to determine whether the plan that you offer provides minimum value. Affordability is determined based on the cost of employee-only coverage. Employee-only coverage cannot cost an employee more than 9.5% of household income. And it's important to note that dependent coverage, which is required under penalty number 1, or offer of coverage to dependents, isn't factored in when looking at affordability. So you have to, the offer of coverage to employees for employee-only coverage has to be 9.5% or less of their household income, but dependent coverage can be more than 9.5% without failing this affordability requirement. The penalty amount on this penalty number 2 is $3,000 per year or $250 per month per full-time employee. And the penalty applies only with respect to those full-time employees who receive the premium credit or subsidy. Thus, even if coverage were offered to an employee, and even if non-affordable coverage is offered to an employee, the penalty won't apply unless the employee goes to the exchange, signs up, and gets a premium tax credit, which, as we discussed, requires that the employee's household income be no more than 400% of the federal poverty level. So, the first of our 7 topics that we're going to discover today is the distinction between legal rules and tax rules. The Affordable Care Act affirmatively requires certain things. These are the legal rules. They include no lifetime benefit dollar limit. You can't, put limits on benefits, a lifetime limit on benefits any longer, which is something that was common prior to the Affordable Care Act. There are restrictions on annual benefit dollar limits, and coverage for dependent children must be required through age 26 for plans that provide dependent coverage. So that requirement was, if your plan provides dependent coverage, then you must cover dependents through age 26. And there's also the requirement that the maximum waiting period allowed is 90 days. These are all legal requirements that, if not met, the IRS can and will impose $100 per employee per failure per day penalty. And so the penalty is quite high, or can be quite high. And in addition, the DOL can impose a civil penalty for ERISA plans, and participants and the DOL can bring civil actions, file lawsuits to enforce these legal rules. The employer mandate, on the other hand, is a tax rule, and so failure to comply, or if you choose not to comply, it's a different sort of penalty. So the distinction is important. Why is the distinction important? It's important for a handful of reasons. First of all, as we've seen, a lot of the sources that we have seen with newsletters coming in or alerts, whatever, they talk about both the legal rules and tax rules as required. It's not quite correct. Under the tax rules, various actions might be advisable in order to avoid the tax penalty, but not required. And there may be times, as we'll discuss momentarily, when it's advisable for an employer to actually take on the penalty rather than strictly comply with the tax rule. And penalty number 2, this is the requirement that the minimum essential coverage offered to employees, full-time employees, be affordable and provide minimum value. This penalty is one in which we believe that it's a situation where you may choose to not always strictly comply with it and rather take on the risk of paying the tax. So in making this decision, you want to compare the cost of providing minimum value affordable coverage versus the potential penalty amount, number 2. For example, we have some clients who are hospitals, and they have non-benefited per diem employees. Such employees, so for such employers with these non-benefited employees, now in order to avoid that penalty number 1, that big $11 million penalty for the 6,000 as an example we used, you're going to want to, you most likely are going to want to offer coverage to these formerly non-benefited employees, but you could choose to offer coverage that isn't affordable. For example, charging them the COBRA rate, that is the full cost of coverage for these employees, which would cover you for penalty number 1, but might expose you to some risk on penalty number 2. But again, that risk is that penalty is triggered only if an employee who is not offered coverage goes to the exchange, receives coverage, and receives a premium tax credit, which again is only available to employees whose income is 400% or less of the poverty level. And the key point here being that the employer might have options, and paying the penalty, this penalty number 2, for some employers, paying that penalty for a handful of employees might be less expensive than providing minimum value affordable coverage to all full-time employees. With that, I'm going to hand it off to Greg, and he's going to take you through the remaining 6 points.
Thank you, Andrew. Topics 2 and 3 that we're going to turn to next continue the theme described by Andrew in connection with topic number 1. That is that the employer mandate is a tax rule, and that there is a fundamental distinction to be made between the substantive legal requirements for which an employer basically has no choice, and the tax rules where an employer might have choices or options. The same dynamic that Andrew described in connection with topic number 1 plays out with respect to the affordability rule. As noted by Andrew, we have penalty number 1, failure to offer coverage, and penalty number 2, applicable if the coverage offered doesn't provide minimum value or if the coverage offered is not affordable. So what is affordable coverage? Coverage is affordable if the employee's required contribution for employee-only coverage does not exceed 9.5% of the employee's household income. And as noted, there is no affordability rule with respect to family coverage. The 9.5% of household income test has some obvious challenges. namely, how does an employer know what an employee's household income is? And as a result, the IRS created some safe harbors, including one in which coverage will be deemed to be affordable if the employee's required contribution for employee-only coverage does not exceed 9.5% of the employee's W-2 wages. And from this starting point, newsletters and commentators frequently suggest that an employer must, or at least should, adopt one of these rules or one of these safe harbors. And there seems to be a particular emphasis on the 9.5% of W-2 earnings safe harbor. And so then some employers, armed with that recommendation from a consultant, set off to modify payroll and related systems to ensure that the required contribution can never exceed 9.5% of the employee's W-2 earnings. Now, when we go through this, let me note at the outset that we're not adverse to any of the safe harbors. So the point in today's discussion is not that the safe harbors should be or must be categorically avoided. That's not the point at all. Our point is simply that the affordability issue is more complicated than the newsletters might suggest, and that each employer will have to think about what is the best fit for its organization. As discussed, the affordability rule is a tax rule, not a legal rule. An employer needs to analyze whether adoption of one of the safe harbors is desirable, since an employer isn't required to use any of the safe harbors. To explore this point, let's ask what happens if an employer applies its standard employee contribution schedule and doesn't make any effort to adjust any systems or to limit the contribution for employee-only coverage to 9.5% of W-2 wages. I think that the conventional wisdom says that the employer is in big trouble if it does this. But is it? The first question to ask might be, how many employees are potentially affected if the employer doesn't use one of the safe harbors? For many employees, the standard contribution schedule likely produces a contribution of less than 9.5% of wages, or less than 9.5% of household income anyway. So the question, it seems to me, is how many employees are potentially affected, how many potentially have a contribution requirement in excess of 9.5% of W-2 wages if the standard contribution schedule is applied. Now that's going to depend upon the composition and demographics of an employer's workforce. In some cases, it may be a sizable number who are affected. In other cases, it may be a very, very small number, which would cause an employer to ask the question, legitimately so, whether it's worthwhile or desirable or advisable to adopt one of the safe harbors. The next question, beyond just the mathematical question of who is potentially impacted, the next question, which isn't as easy to answer as the first one, is how likely is it that employees for whom the standard contribution schedule will produce a contribution in excess of 9.5% of W-2 wages, how many of those employees will actually obtain coverage through the marketplace and will actually qualify for a subsidy or premium tax credit as a result of that marketplace coverage? As Andrew noted, the B penalty, or penalty number 2, applies only with respect to those employees who show up on the marketplace, obtain coverage through the marketplace, and qualify for that subsidy or premium tax credit. So the basic question here is, what is an employer's real penalty to exposure if it doesn't adopt any of the safe harbors? What you might do depends upon the demographics of your workforce. If you conclude that for your business, the standard contribution schedule will produce a contribution of less than 9.5% of wages for all but a few employees, again, an employer in that situation might decide not to do anything special relative to the affordability rule, even though such an action makes it possible that the employer could have penalty to exposure with respect to a few employees. It's a cost-benefit question like most other business questions. What is the cost of modifying systems? What is the cost and desirability of applying one of the safe harbors versus what's the potential cost of penalty number 2 in the event that it applies, and to how many employees might it apply? Also, when thinking about the safe harbors, such as the W-2 safe harbor, think about whether there might be unintended consequences that flow from the use of the safe harbor. For example, let's say that an employer wants to be absolutely certain that it does not pay any amount under penalty 2. So it hard codes into its payroll system a rule limiting the employee contribution for any period to 9.5% of wages for that period. Now, having done that, let's ask ourselves the question, what happens when an employee goes on an unpaid leave of absence? 9.5% of $0 of wages during the unpaid leave of absence is a 0 employee contribution during the period of leave. Is that an acceptable result for the employer? It might be. It guarantees that the affordability rule is satisfied. But on the other hand, it might not be. It might be viewed as unfair by the employer that an employee who goes out on leave doesn't pay a contribution. Now, interestingly on this point, the preamble to the IRS regulations acknowledges that the Form W-2 wages safe harbor might be impacted by an unpaid leave of absence. So it certainly appears that the IRS is well aware of the leave of absence issue and that this result isn't an unintended oversight on the part of the IRS. The final thing to note with respect to the 9.5% of W-2 wage safe harbor is that even though compliance with the test is ultimately measured on an annual basis, did the employee's contribution for the test exceed 9.5% of wages for the year, the IRS doesn't permit an employer to make discretionary mid-year adjustments in the amount or percentage required to be contributed by the employee. The employee's required contribution must remain a consistent amount or percentage of W-2 wages during the year. So, for example, an employer cannot increase the employee contribution for some periods in order to catch up for contributions that might have been missed during prior periods. If the employer does that, it doesn't appear to qualify for the safe harbor. Now, again, I'm not arguing against the use of a safe harbor in today's presentation. If the leave of absence issue is a concern, there's another safe harbor that is based on rate of pay and that isn't impacted by unpaid leaves of absence. So there may be a safe harbor that's the right fit for an employer. But the key point for purposes of today's discussion is that this is not a one-size-fits-all proposition. Rather, an employer needs to think about which safe harbor, if any, is the best fit. There is no requirement to use any of the safe harbors. And so an employer has to understand the implications of, if it uses a safe harbor, has to understand the implications of the safe harbor it's chosen and whether those consequences are acceptable, even though they may have the desired effect of insulating the employer from penalty number 2. It's exactly the point that Andrew was making, which is that there are choices and an employer has to sit down and analyze what is the best fit for its situation. Let's move on to topic number 3, which is entitled Challenging Assumptions. The premise here is that sensationalism sells, and newsletters and consultants sometimes paint a worst-case scenario as if that were the likely scenario or the required outcome. Let's begin with a discussion with the following hypothetical. Let's say that an employer has 238 full-time employees who are not currently offered coverage. And a consultant calculates that the estimated cost to cover these employees under the employer plan, some who will have employee-only coverage, some with family coverage, is $2.8 million. An average of about $11,750 per employee. However, let's consider those numbers more closely. The $2.8 million estimate likely assumes that all 238 employees will enroll and that the coverage will be offered under the same terms and conditions as apply to all other eligible employees. That is, same coverage, same terms and conditions, same employee contributions. However, consistent with the comment that Andrew made, there's no requirement that the 238 be offered coverage on exactly the same terms and conditions. For example, the employer could offer employee-only coverage with an employee contribution that satisfies the affordability rules and family coverage with a high, COBRA-like employee contribution. Remember the point that there is no affordability rule for family coverage. Alternatively, the employer might offer comparable coverage, but with a high COBRA-like employee contribution for all levels of coverage, including employee-only coverage. In this situation, the employer might be subject to penalty number 2, but it will avoid penalty number 1. Penalty number 2 might apply because the coverage offered when there's a COBRA-like premium offered, COBRA-like employee contribution required for all coverage levels. Penalty 2 might apply because the coverage offered will be unaffordable. But once again, penalty 2 only applies with respect to those employees who enroll in marketplace coverage and receive a premium credit or subsidy. Some employees might in fact qualify for the premium subsidy, so I'm not trying to be cavalier about penalty number 2. But in order for an employer to determine the best approach, the employer needs to understand the potential numbers. For example, let's look at it this way. If all 238 employees enrolled on the marketplace and qualified for a subsidy, the employer's penalty number 2 amount on an annual basis would be $714,000, which is 238 times $3,000. Now that's a big number to be sure, but it's about 25% of the $2.8 million cost noted by the consultant in our example. Although note that if one got a little more sophisticated with the analysis, there are some tax efficiency issues in that the $2.8 million, if used to provide benefits, is tax deductible by the employer, and the $714,000 penalty 2 amount is not tax deductible by the employer. But for a starting point in the analysis, we start off with a penalty 2 amount of $714,000, which is compared to a $2.8 million number floated by the consultant in our example. Now, if we start with that $714,000 number, in all likelihood, the real penalty 2 amount is going to be less than that. Employees might not go to the marketplace because they might have coverage under a spouse's plan. An employee might go to the marketplace but not qualify for a subsidy because total household income exceeds the thresholds. Or an employee might choose to pay the individual tax and go without coverage. Again, I'm not trying to be cavalier about penalty number 2, and I realize that the HR department is going to need to explain to the remainder of the organization the logic and financial consequences of any plan design. But for purposes of our discussion today, the theme remains constant, that there's a flow of information saying that you must do certain things. But in reality, there are some options, and you need a more sophisticated analysis, not a one-size-fits-all answer. At this time, I'll just take a quick minute break from the presentation to announce the 4-digit code for those seeking Kansas, New York, and New Jersey CLE credit. The code is KS0B. One more time, the code is K as in Kilimanjaro, S as in Sierra, 0, the number 0, and B as in Bravo. That takes us to topic 4, must an employer count hours? The starting point here is that the employer mandate applies to full-time employees, and full-time employees is defined as averaging 30 or more hours per week. So the issue becomes how to determine if someone has an average of 30 or more hours per week. There is a general rule on this, the rule that appears in the statute that Congress passed, but it rarely gets mentioned. The general rule is a month-by-month determination. If an employee averages 30 or more hours per week during a month, the employee is a full-time employee for that month. Notice that it's for that month, not for the next month, so that the way the rule literally reads, if an employee averages 30 or more hours per week for the month of October, they are a full-time employee for the month of October, and they count as a full-time employee for that month of October in my example for purposes of penalty A and penalty B. For many employers, of course, the general rule creates a logistical issue. If we wait until the last day of the month to determine whether an employee is a full-time employee for that month, how do you then go back and offer coverage for that month, or have you, or if you don't offer coverage for that month, are there consequences for purposes of penalty A and penalty B that really were inadvertent because you just didn't know whether the person was a full-time employee? Given the logistical issues inherent in the general rule, the IRS created something known as the look-back method. Basically, the rule the rule uses look-back and stability period concepts in which the hours completed during a period, the look-back period, say 2014, are used to determine whether an employee will be treated as a full-time employee during the succeeding stability period, say 2015. One point of confusion with the look-back rule is how to apply it to new employees. For ongoing employees, the concept seems clear. For example, you look to 2014 hours to determine 2015 eligibility. There's various options, but that's the general concept. But what to do for a new employee who has no prior history? Here, the IRS rules say that you can't use the look-back method during the initial employment period if the new employee is expected to average more than 30 hours per week. You can only have a 90-day waiting period, but otherwise, these employees who are expected from the date of hire, expected to work 30 or more hours per week, must be offered coverage for purposes of penalty 1 and penalty 2, or treated as full-time employees without an offer of coverage for purposes of the penalty once they've completed, or the first day of the month following their completion of 90 days of employment. Once they have a history, then you can use the look-back method to see on an ongoing basis whether or not they are full-time employees. But for new employees, again, if the employee is expected to work 30 hours per week from the outset, you can't use this method during the initial year of employment. You can only use the look-back method for new employees during the initial period of employment up to a year if the employee has a variable work schedule such that it's not reasonably apparent at the date of hire whether the employee will average 30 hours per week or less than 30 hours per week. So for variable hour employees, the look-back method actually allows the employer to hold the employee out of coverage for up to a year while determining whether the employee will meet the definition of full-time employee. But this works only for variable hour employees. You don't get a free one-year look for all new employees. And that's a point of significant confusion among employers who sometimes think that you can apply the look-back method to all new employers. Now, when we talk about the look-back method, there's been so much discussion of the method in newsletters and so little discussion of the general rule that one can easily believe that the look-back method is required. And for many employers, I will be the first to admit that the look-back method will be the preferred method and the only practical approach. The classic example of this is an employer who has variable hour employees and for whom the employer would prefer not to offer coverage unless it feels it needs to do so for purposes of the penalty provisions. However, let's just ask ourselves the question, what if an employer only has regular full-time employees or part-time employees with stable hours so that the part-time employees never average 30 hours per week? In that situation, might the employer simply offer coverage to everyone who's scheduled to work 30 or more hours per week? Doesn't that comply with the employer mandate rules, or the offer of coverage portion of the employer mandate rules? In that situation, what purpose is served by counting hours? So when a consultant talks about how you have to design a system to determine who is a full-time employee for purposes of the PACA, and that system involves counting hours and it's very complicated, that probably is correct for many employers, but you should ask more questions and you should challenge that consultant if you have a workforce with stable hours where employees clearly and consistently either average 30 or plus hours per week or consistently are below 30 hours per week. In that latter case, you may not need to fully implement all of the nuts and bolts of the look-back method in order to comply with PPACA. There may be simpler ways to do it, but those simpler ways just don't get discussed in the newsletters. The newsletters talk about the full-blown look-back method, and again, there might be easier ways to comply. Topic number 5, independent contractors. In the benefits and tax world, there have always been issues with respect to the question of whether a person who is classified as an independent contractor is really an employee of the employer. For example, the IRS might allege that a person's really an employee and therefore the employer had an obligation to withhold income taxes or FICA taxes on the amount that was paid to the service provider. And similarly, there might be questions of whether the service provider should have been eligible for coverage under the employer's benefit plan, such as the medical plan or the 401k plan. If the employee should have been allowed to participate in the 401k plan, then the employee would have had an opportunity to earn a matching contribution above and beyond the amount which was otherwise paid to the person classified as the contractor. So those issues have always been present. But PPACA adds an additional layer to the independent contractor versus employee issue. Because now the independent contractor versus employee issue is relevant for purposes of penalty number 1 and penalty number 2. For example, if one or more independent contractors are reclassified as employees, let's say the IRS comes in and says some of these folks aren't really independent contractors, they're employees. So they're reclassified as employees, but they don't have an offer of coverage because we treated them as not being eligible for coverage. Is the 95% test under penalty 1 still satisfied? 70% test for the 2015, but on an ongoing basis, is the 95% test under penalty 1 still satisfied? Now that may depend upon what your comfort margin was with respect to penalty number 1 to begin with. If the 95% test had been easily passed, that is, you're a big organization and your ratio was 99% or 100%, then the reclassification of 1 or 2 or a few independent contractors to employee status might be a non-issue, even though you didn't offer them coverage. Because if you were at 99% and you reclassify a couple of people, or the IRS forces you to reclassify a couple of people, maybe your 99% becomes 98% and you still pass the test. However, what if the 95% test was being passed with little, if any, margin for error? What if you were just squeaking by at 95.2% because you had a group of employees who weren't being offered coverage already, so that you weren't at 100%, your 95% test was very close? The question then is whether the reclassification of the independent contractors might take on added significance. And as Andrew pointed out, if that causes you to fail penalty number one, those results are potentially disastrous. Andrew gave the example before of an employer with 6,000 employees for whom the penalty for failure to comply, for which penalty number one, the penalty amount on an annual basis was $11,940,000. And so the independent contractor issue is something that you should be aware of, especially if your margin for error with respect to penalty number one isn't very great. Also, as an aside on this issue, because PPACA applies to employers with 50 or more full-time equivalent employees, one argument that sometimes gets made is that an employer might avoid PPACA by keeping its employee count to 49 and then using independent contractors for the remainder of its work. Again, you got to ask yourself, are all of those independent contractors really independent contractors, or does PPACA apply? Topic number 6 of 7. This topic is entitled Beware the Small Subsidiary, but the larger point is that penalty 1 applies in a manner that might not be intuitive to all of us. Many of you work for organizations that include a group of companies. There might be a single common medical plan design, and there might be centralized benefits administration. And when that happens, we might quite naturally think of the medical plan as the company X medical plan, and we talk about it as a single company, even though there might be 5 or 10 or even 20 companies that fit under the company X umbrella. The fact of the matter is that a large number of employers have not just one company. There are subsidiaries and affiliates, and there may be employees in each, even though for benefit purposes, there's a common design and a common platform, and we don't necessarily distinguish for the most part, and we don't necessarily worry about which of the 5 or 10 or 20 companies a particular participant is employed by. They're just covered under the plan. They get the same level of benefits as any other employee, and so we tend not to worry about it. However, for purposes of penalty number 1, identifying the specific entity that employs each full-time employee is important. This is because each company must separately satisfy the 95% test with respect to its full-time employees. It's not one big test. Rather, it's a separate test for each entity. And the way the math works, the smaller the number of employees in an entity, the more likely it is that the exclusion of a few employees or the reclassification of a few independent contractors might be important, because the margin for error, that 5%, just isn't very big when you only have a handful of employees or a small number of employees to begin with. Now, I don't mean to suggest that the entity-by-entity approach is all bad. It isn't. Significantly, if the 95% test is violated, penalty number 1 applies only with respect to the full-time employees of that entity. So the penalty amount will be smaller because you're only looking at the full-time employees of that entity, but the likelihood of inadvertently tripping up, it could be greater. That brings us to our final topic for today, topic 7, phantom exemptions. What we're referring to here is an exemption that people think is or should be there, but it isn't. There are no exemptions for collectively bargained employees or temporary employees, although there are some rules for seasonal employees in the IRS regulations. Let's start with the bargaining unit employees. A bargaining agreement may provide that a class of employees is not benefit eligible. That is a permissible provision in a collective bargaining agreement, And there's nothing in PPACA that requires an employer to offer coverage to all employees. Again, that's the basic distinction that Andrew went over in terms of legal rules versus tax rules. So that if an employer negotiates with a bargaining unit to exclude a category of employees from coverage, there is nothing in PPACA which is categorically violated as a result of that. That is a permissible collective bargaining provision, and PPACA does not override the employer and the union's right to negotiate that kind of provision. But here's the key point. The fact that you bargained it doesn't provide an exemption to the employer for purposes of PPACA. It doesn't provide an exemption with respect to those employees for purposes of penalty number 1 and penalty number 2. So the employees who've been excluded, if they qualify as full-time employees, have to count as an employee without an offer of coverage for purposes of penalty number 1, and that's a question of do you still satisfy the 95% test, and they also wouldn't have coverage for purposes of penalty number 2 if that becomes applicable. There just simply is not a collective bargaining exemption, even though employers quite frequently believe that there should be, or they think that if it's bargained that there is an exemption. The story is similar with respect to temporary employees. Again, there is no blanket exemption. A temporary employee can be a full-time employee. If the temporary employee is a full-time employee, coverage can be delayed for 90 days under the permitted waiting period rules. But the definition of full-time employee does not mean full-time permanent employee or full-time regular employee. And that's the key point here. I know from an employment perspective, many employers have various classifications of employees. And they'll have what they might call regular employees or permanent employees, people whose job has an indefinite time duration and who are expected to work 40 or more hours per week, that type of thing. And so when they say temporary employees, they don't think of a temporary employee as a full-time employee because they associate the word full-time employee with regular or permanent or indefinite employment. But PPACA does not make that distinction. PPACA defines full-time employee as averaging 30 or more hours per week. And it doesn't carve out a special rule for an employee who's hired to work 30 or more hours per week for let's say 10 months and will then be terminated. That second part, that the idea that the employee is temporary, isn't part of PPACA's definition of full-time employee. So what that means is that if the temporary employee at the date of hire is expected to work 30 or more hours per week, the employer cannot use the variable hour look-back rules because, again, at the date of hire, the person wasn't a variable hour employee. Their schedule was set enough. They were going to work 30 or more hours per week. And so the employer, after the 90-day period, has to either offer coverage or treat that employee as an full-time employee without an offer of coverage for purposes of penalty 1 and penalty 2. Further, in determining whether the employee is expected to average 30-plus hours per week, the IRS has clarified that an employer needs to look at the expected hours during the period of time that the employee is actually employed by the employer. There initially was confusion over this point, and some employers would take the position or took the position that an employee who is working 40 hours per week for 26 weeks is not a full-time employee because the employee over the course of the whole year will only average 20 hours per week. The IRS permitted this reasoning during a transition period, but clarified that on an ongoing basis, an employer must look at the average hours employed during the period of employment. So if there's a temporary employee who during the period of employment is consistently, and is expected to and is consistently averaging 30-plus hours per week, that employee is not a variable hour employee, and they can't be held out or without being considered as an employee without coverage for purposes of Penalty 1 and Penalty 2 more than the 90-day initial waiting period. If the temporary employee truly is a variable hour employee, then it's possible to use the look-back rules and potentially hold the person out even longer. But the key point is that the way that employers typically classify temporary employees or tend to classify employees by attaching some rule of permanency or indefiniteness to their employment relationship, that doesn't apply to PPACA. And as a result, there's no blanket exemption for temporary employees, and they must be analyzed for PPACA purposes like any other employee, consistent with the topics and the concepts that we've been discussing throughout the day. That brings us to the end of our time, and so we've exhausted our time. Thank you very much for your participation. That concludes our web conference today. Please take a minute and give us your feedback about the presentations using the link provided. It's important to us to know your thoughts, and it helps us shape our programs going forward. Again, thank you for your participation.
That does conclude today's conference.